Welcome to this episode of the Sangamon County Circuit Clerk Presents. I'm Betsy Moore. The following program is one in a series of programs on various topics of public interest that concern the Circuit Clerk's office, their various departments, and the issues they deal with. These programs are produced for your benefit in the hope that the information contained within will help you better understand the role and the scope of the Sangamon County Circuit Clerk's office.
Okay, so we've talked about our first two steps. One, why am I evicting the tenant? Important question. Answer is more important because it determines the type of notice. And as far as our notices, what have we learned? We have learned that they all have things in common. What are those? Again, in writing, signed by the landlord, his, her, or its agent, must name the tenant, must name the premises. The next step is service of that notice. So again, we've asked the question, why, which has allowed us to pick the correct notice out of this inventory of notices. We've got it in the correct form. And now what do? I serve it. How do I serve it? For everybody out here in the audience today that are keeping the citations, this is Section 211 of the Eviction Act, Section 211. There are 4 ways and only 3 count. What do you mean by that, Mike? The service is as follows. Personal delivery of a copy upon the tenant. Yes, are you the tenant? Yes. Here's the copy of the notice. Does it have to be the original? No. We'll get into that. That's called the rules of engagement. We'll get into that. 2, by service of anyone in possession of or residing at the premises that is 13 years or older. 17-year-old answers, hi, is your mom home? No. Will you give this to her when she gets home? Yes. Good service. 3, by certified or registered mail addressed to the tenant at the premises. Now that sounds like a really nice option, but here is the rule. This is the one thing that makes this very difficult. With a returned receipt from the addressee, meaning you must send it by certified mail, return receipt requested, and you must receive back the certified green card. Unclaimed or refused is not good service under the Eviction Act. So in a way, it's a very ineffective way of serving a notice. Because if you try to serve a notice and you send it by certified mail, the post office, who is trying their best to get it delivered, is going to do a first attempt, second attempt, even maybe a third attempt. All the while, by the way, you're still out at possession premises. And if the tenant doesn't ultimately pick it up, it comes back unclaimed, and it's not good service anyway, and there was probably 2 or 3 weeks down the drain when you could have just went over and had it served to the tenant personally or somebody above the age of 13 years. Or 13 years or older. The last way, and the one I said that doesn't count, how can there be 3 and there can be there before and 3 only count? If no one is in actual possession of the premises any longer, then by posting it on the premises. Just posting it on the door. Very important. Posting is allowed if no one is actual in possession of the premises anymore. But that's it. So, to recap, what's our 4 ways? Personal delivery, 13 years or older at the premises and we're in possession of it. Certified or registered mail, must have the green card back. Or if no one's in actual possession anymore, then you can post it on the premises. Okay. That's it. Meaning, what about sliding it under the door? No. How about putting it in their mailbox? No. How about an email? No. The law, again, going back to the first part of our discussion, if you do every of the steps correctly, you can't lose. If you do one of the steps wrong, you can't win. All right, there's your 4 methods. Only 3 count, in the sense that the 4th one is not available unless there's nobody there. And again, I'm beating this to death because this is the biggest problem I see when people on their own are doing evictions. This is the biggest problem right here. Okay. I ask, how'd you serve that notice? Slid it under the door. I watched somebody pull it. Somebody pulled it out from underneath as I slid it. Good? May very well not be. Okay. Commonly asked question is this. Rules of engagements. How it's accomplished. I'm the landlord. Can I do it myself? The answer is yes. Do I have to take a witness? No. Well, how do I prove it? Your testimony in court, which is going to be the lawsuit part, which is what we're going to talk about here next, okay? The lawsuit part. Well, actually 2 steps here. The lawsuit, okay? The judge is going to listen to your testimony. You're going to be under oath, under the penalty of perjury if you lie, and you're going to tell the judge the truth. I handed it to him or her, or I handed it to the 17-year-old son, or whatever it was. If you have a witness, is it helpful? Sure, it's helpful. But that person has to be live and in court if the matter goes to trial, and they have to do the same thing. They have to testify to the judge. I was with the landlord on November 1st, and this is how the landlord served it. Do I have to serve it? The answer is no. Do I have to serve it myself? The answer is no. Who can I have? You can have a process server. Who is that? That's somebody who is above the age of 18 years and not involved in the transaction or the lawsuit to come. That will work. What about a private detective? Yes, a private detective is fine. How about the Sheriff's Department? The Sheriff's Department likewise will serve an eviction notice for you. All 3 of private process server, a private detective, or a Sheriff's Department will charge you a fee. So you can serve the fee as long as you do it correctly like we've just discussed. Another question, do I have to explain it? No. Can I put it in an envelope? Yes. Do I have to mark what the envelope is? No. When I hand it to them, does it have to say, open, important, 5-day notice, must open immediately? No. Do they have to sign for it? No. Does it have to be notarized after, before, or after I serve it? Now again, on the circuit clerk's form, you're going to see a provision for a notary. I think it's a little bit misleading. Under the law, does it have to be notarized? Even though there's this notary part in the circuit clerk's form, the answer is no. It does not have to be notarized. Okay. Yeah, big. I get that a lot. That's like one of my more, second most questions I get in a month. Does it have to be notarized? Answer is no. Just must be signed by any of you or your agent. By the way, who's my agent? My agent could be anybody you authorize. What if I authorize my wife? She can sign it. What if I authorize the cameraman here today? He can sign it. He's your agent, but must be signed. Okay, but not notarized. Okay. So, quick recap. Asked the right question, determined the right kind of notice, got the right form for that notice, served it correctly. What's the next step? This is one of the hardest steps in the entire process. Wait. Yeah, wait. That is the hardest, to me, one of the hardest parts of the entire process. Example, you see this happen, and this is, again, a common thing that happens. Landlord serves, back to our 5-day notice example, remember that one here we talked about earlier? Landlord serves the 5-day notice today on Wednesday. And goes 5 days is Wednesday, Thursday, Friday, Saturday, Sunday. Okay, Wednesday, Thursday, Friday, Saturday, Sunday. And files it first thing Monday morning. Now, what's the real amount of time? Thursday, Friday, Saturday, Sunday, Monday night at 11:59 p.m. But the landlord is in a hurry because the waiting, I understand, is hard. So say the landlord goes Wednesday, Thursday, Friday, Saturday, Sunday, 11:59, 8 o'clock Monday morning, files a lawsuit. Gets to court. Judge sees that, case dismissed. What? Case dismissed. Why? They owe the rent. He just admitted they owe the rent. You didn't wait the full 5 days. You file that lawsuit within that 5-day period, you automatically lose. 30 days, same thing. I filed it on December 28th because I was back in town. I didn't wait until in our 30-day notice. I didn't wait till, I filed it on November 28th because I'm back in town. I didn't wait till December 1st or whatever in our example on a 30-day notice. If you file too early, you lose, which is really kind of odd because every other law that anybody's going to talk about here today, you lose if you file too late. That's called statute of limitations. And that's going to be for some other person, guy or person, up here talking all about that. That's an entirely different seminar, okay? But that's the statute of limitations. For example, 2 years. If you're in a car wreck, you have 2 years from the date of injury in which to file a lawsuit. And if you don't file within that 2 years, you can't file a lawsuit and you're out. Eviction is the one law where it's all in reverse. You lose if you file too early. So the step is wait. I preach what's called the 24-hour rule. If you're not sure when that lease ends, wait 24 more hours before going to the next step, which we're about to talk to, and that's file the lawsuit. Okay. 24 hours. If you're not sure, wait that extra day. If it's 30, wait 31. If it's 5, wait 6. If it's 10, wait 11. Okay. Be absolutely sure you do not file within that time because it's automatic dismissal. Now, I've asked the correct question, which gave me the right notice to use. I put it in the right form. I served it correctly, and I waited the right amount of time. What's the next step? The lawsuit. Lawsuit? Lawsuit. I do get this every once in a while. Hey, I served a 5-day notice and they didn't pay me in full within 5 days, and now I can go in and change the locks and throw them out. No. What? The notice, everything that we've talked about up to this moment has just been the things that unlock the right, that open up the right to file the lawsuit. What's the goal of the lawsuit? It's for the judge to give you an order joining this possession back to you, the landlord. That's our goal. Okay. Now, the lawsuit. May I file that myself? The answer is yes. The answer is yes. Is there a form that the circuit clerk's office in Sangamon County provides for that if I want to do it myself? The answer is yes. Can the circuit clerk give me advice on how to fill it out? I can tell you this, on behalf of the circuit clerk, the answer is no. They are precluded from giving you legal advice. But the form is one page, the form has boxes, and you need to provide all the information that's requested. You also need to attach a copy of your lease or notice to that complaint. Attach a lease, any written lease that you may have, and the notice. Will that form work? Yes. It says everything that the law requires. It says everything in it. In it, it says everything that the Eviction Act requires a complaint to have to say. Can I try to draft one myself? Yes. Yes, yes. But if you get creative and you deviate away from what the statute's required, and we're going to talk about that, you can lose. If you're going to do that, my advice, stick with circuit clerk's form. Can I hire an attorney? Yes. Do I do them? Yes. Yes. You can hire me? Yes. And You don't have to worry about any of that because, again, what we do is that's only one part of my job is to make sure that that says everything it needs to say. Okay. The complaint, it needs to identify who the landlord is. It needs to identify who the tenant is. It needs to identify the address of the premises. It needs to set forth facts as to what happened. I had a lease, signed on this day, and it said no dogs or no animals, not even to visit, without written permission of the lessor. And on November 1st, I came by the premises, and there was a Great Dane the size of a small pony. And I picked the right notice. I filled it out in the correct form, signed it. I served it correctly. I waited the proper number of days under that form, 5, 10, 30, 7. And now, as a result of all that, the tenant unlawfully withholds possession of the premises from me. That's the basics for an eviction complaint under the Eviction Act. Now, where do I do all this? I do it at the Circuit Clerk's office. Where's the Circuit Clerk's office? It is in the Sangamon County Courthouse. In Sangamon County, it's here at the courthouse. It is room 405 of the county building. Forms are provided. Is there any other forms I need? The answer is yes. Well, what else do I need? You need a summons. What's a summons? A summons is essentially a glorified invitation to attend court. It's a notice to the tenant, who's now the defendant. There's going to be a hearing at this time, at this date, and you need to be there, or if you're not there, a default judgment can be taken against you. That is likewise issued by the clerk. Do I have to fill that out? Yes. Is it easy to fill out? Well, relatively. Can the clerk give me any advice on filling that out? The answer is no. They are precluded from giving you legal advice, folks. I get that. I hear that a lot. And again, they can't give you legal advice. They're not lawyers. Always get hold of me or anybody here in the bar that does landlord tenant or anybody else. Anybody else who's licensed to practice law, you can talk to them, but you can't talk to the clerks, and it's hard on them. Okay. Now, may I serve that summons and that complaint myself? Because it has to be served. That's the next step. So first is the right form of the complaint. Second is the summons. How do I serve all this? Do I have to serve it? Yes. Do I have to serve just the summons? No. Do I have to serve both the summons and the complaint together? Yes. Can I do it myself? No. Well, who can do that for me? A person authorized by the court, called a process server, can do that for you. They're above the age of 18 years, and again, they're not a party to the action. A licensed private detective who is licensed under the Private Detective Act of Illinois can serve that for you. Doesn't need the judge's permission. Doesn't need a special order. Or our good sheriff's department, and they are available to serve the summons as well, summons and complaint. Together, that's called process, by the way. The fancy word is process. Okay. So they serve process, which is summons and complaint. If I file my complaint and I have the clerk issue a summons, when's my hearing date? Okay. Currently, in 2013, I'm going to show you how to do eviction math, the way things currently are here in Sangamon County. You need to know 2 rules to do eviction math. Eviction math tells you when your court hearings generally are going to be, and there's exceptions. But the general 2 rules are this. The first one, evictions are only held on Fridays. That's per this courthouse. And 2, by law, by Illinois law, there must be at least 7 days from the day you file it to the day it's in front of a judge. That's 2 rules you need to know. So, today is Wednesday, right? Right. I go downstairs, I go to the circuit clerk's office, I file my complaint, have the summons issued today. And our flow chart looks like this. Have the summons issued. What's today? Today is Wednesday. When's the next available Friday? This one coming up, November 8th. Is there 7 days between those 2 days, between Wednesday and this Friday? No. You go to the next Friday after that. It will always be the next Friday that is more than 7 days from the day you file it. What if I file it on Friday? You can set it for next Friday. Can I file it Monday and set it for that coming Friday? No. But if I set it for that if I file it on that previous Friday, can it be heard the next Friday? The answer is yes. 7 days. When does it have to be served? Again, this is going to be up to whoever you hire. And again, this is a hire. Your process server, your private detective, or our sheriff's department has to be served at least 3 days prior to the hearing, which means by Tuesday of that week, it needs to have been served. What happens if it's served? What happens if it isn't served what if it isn't served by a Tuesday of the coming week and the hearing's Friday? When you appear in court, what's going to happen is the judge is going to say continued for service. You didn't get service. You didn't get service within the right amount of time. You had to do it at least 3 days prior to the hearing. You didn't get it done. Oh, well, what do? You go back downstairs. You ask the clerk for an alias summons, and they're going to give you a new date, which will be the next Friday. That's more than 7 days from the day they give you that notice, which is usually the next Friday, You take that down, you give it to your process server or the detective or the sheriff's department, and again, they go out and try to serve it again. Now, again, this is up to your professionals that you hire. And even for the lawyer, this is the part that's out of our hands. One other thing, though, that they can do for service, and I want to make everybody aware of this because this is where a lot of people don't get things served, and it's possible for it to get served, is this. It's called constructive service. With a regular process, they have to serve it the normal way, just like we discussed. You have to give it to them personally. You have to give it to somebody who resides at their home that's 13 years or older. But what if they've hidden themselves where they can't be served? What if they have left the state? That's what the statute says. Well, how do I get them served now? There's a procedure. And again, for the folks or everybody out there that's keeping track, it's Section 107 of the Eviction Act. It's called constructive service. If the process server, detective, or sheriff's department goes through the procedures in that, they're allowed to post the notice on the premises and in 3 public places, do a special affidavit, do a mailing. Again, this is what you don't worry about. It's the people you hire. That's their job. And again, the people that, for example, my law firm uses, they know exactly what they're doing. And the only thing is that it's got to be at least 10 days prior to the first time a judge hears it, from the day they post it in 3 public places. And again, check with your process server, check with your detective, check with your sheriff's department personnel on that scheduling, and they'll take you through it, okay? But just keep in mind that even if they're hidden, they're hiding, you can still get an eviction order. Now, if they're personally served and you have a rent claim, the only thing you can add is a rent claim. Well, what about my broken window? No. What about the utilities that they owe me? No. In fact, if that's in your 5-day notice, you added utilities, you added broken windows, instead of just rent and maybe some late fees, you can be thrown out on that. Only a claim for rent can be in the notice, and only a claim for rent can be brought in the lawsuit, nothing else. Well, what about the broken window? What about these utilities? I get that a lot. Here's my answer. The court is not saying that they don't owe that money. They may owe it, they may not owe it. But that's a different lawsuit and a different day. Well, why can't I only put rent in there? Why can't I put broken utilities in that, or the utility or broken window in that notice? Because that's not what the notice is for. The notice, again, folks, is just that jurisdictional procedure that unlocks the right to the lawsuit. What can I do about my utilities and my broken window? Small claims court, which is a whole different seminar. Small claims court. Okay. What's the process in the lawsuit? Very simple. 2 parts. First appearance, which is on that Friday. Yes or no? That's the only thing that happens at the first appearance. You still have to be there. If you're representing yourselves, you still have to be there. Because if you're not, the judge can dismiss your case. But you don't need to do anything at the first appearance. Yes or no? And that's the question for the tenant. Do you owe the rent? Yes or no? Did you violate the lease? Is it the end of the term and they gave you a 30-day notice? Yes or no? If the tenant says yes, the court issues an order. Now, the rule currently here is they will give you 1 week. They will give the tenant 1 week. Everybody gets 1 week. If they say no, it'll be set for trial. Well, when's the trial? Again, doing our eviction math. If it's this Friday is the first appearance, trial is generally set for that coming Tuesday. Well, what happens if I win at trial? If you win at trial, the move-out date is still 1 week from this Friday. So asking for a trial does not get by anyone any more or any less time. Okay, very important to know. So what happens at trial? How do I prove my case? You prove your case exactly what we've just discussed, and this is where we're going to conclude. You're going to prove at trial exactly what we discussed at the very beginning. I picked the right notice. I did it in the right form. I properly served it. I waited the correct number of days before bringing my suit. I filed my suit using the proper form. I had it properly served, and I'm here. That's it. That's your trial. That's a core. Now, that would be an entire another hour seminar, by the way, if we wanted to talk about the nuances of trials, okay? And if you prevail, the judge is going to give you what's called an order to vacate. Ooh, it's going to give it for this Friday. That means I can take a baseball bat and go down there and bash the guy in the head and pull all his stuff out. No! No, you can't. What do I do with that order? That order is enforced by the Sheriff's Department of this county. And they will schedule a time and date for you to come out, for them to come out. They will assist in removing any persons, and you're left to deal with removing any property. Okay, folks, that's it. Now, and on the Sheriff's Department, you can consult with their staff. They're very friendly, they're very helpful, and they will answer all your questions. So, once you have your eviction order. That's it, folks. That is the entire nutshell or summary of how we do eviction law here in Illinois, and more particularly in Sangamon County. And thanks for coming today.
Thank you for watching this episode of Sangamon County Circuit Clerk Presents. These programs are produced for your benefit, to help you in your interaction with the court system. They're accessible on the Circuit Clerk's website and YouTube channel, as well as the City of Springfield's Public Access Channel 4. I'm Betsy Moore.